This is a definitive guide to literally every question that you may have about this topic. Everything that you could possibly want to learn will be covered. Step 1, what is theft? Okay, so I'm going to break this down into two different pathways. The first is going to be this, so the basic understanding, just to give you a general overview of theft in its essence. And then the second part, for those that are a bit more curious, I'm going to give you the first class way. So I'm going to literally break down everything you could possibly want to know, every potential outcome, all the cases, information, legal knowledge that you need, I will go through here. But let's start with the basic understanding. Okay, so firstly, the main thing that you need to know is the Theft Act of 1968. This is the current legislation that is governing theft in the UK. So let's go into a bit more detail. So I've broken it down into two different pathways. I'm going to give you a simple explanation of what it actually means and what it actually says. So let's start with what it actually says. So in section 1 is the offence of theft, and it's also important because the Theft Act also consists of other legislative other areas of law. It covers burglary, it also covers robbery as well, but section 1 is primarily the offence of theft. So it says this, that you must dishonestly appropriate property belonging to another with the intention of permanent deprivation. This is the offence of theft. So what does this actually mean? Okay, so if we go to simple, it ultimately means if you take someone else's stuff with the intention to never give it back to them. So this is ultimately all you need to know if you want a basic understanding of theft. Thanks for coming. But there are a lot of loopholes within this definition, which we will explore now. So if we go back, so that's the basic understanding finished. Let's go to the first class way. So there are two aspects that I want to talk about. The first is the history of theft, how it has developed and evolved over time in England and Wales. And the second is, where is it? The Theft Act 1968. We're going to break that down in a lot more detail. We're going to break down what does it mean by appropriation and all the other factors. Okay, so let's start with the history. So, before the Theft Act of 1968, we had the Larceny Act of 1916. And this said this, that a crime of larceny, or what now would be theft, you have to steal something without consent, fraudulently, without a claim of right made in good faith, by taking or carrying away anything capable of being stolen with the intention of permanent deprivation. And also consider, if we reflect back to the offence of theft, section 1 in the 1968 Act, the difference between what it says about the Act here and how the offence differs then and now. Okay, so now, let's break this down. So there are two parts. We're going to look at why, in essence, this was replaced with the Theft Act. So was it terrible or was it good? So on the good side, we're thinking of this. So its purpose ultimately was to consolidate and simplify the law relating to larceny, because ultimately they had a number of different offences that related to theft. And what this act did, the 1916 Act, is compile them all together into one simple act. So that's why a lot of people thought it was a good thing. But it was also a bad thing because, well, it was replaced with the 1968 Act, and this is what happened. A lot of people believe that it was very complex and inconsistent. Changes made from this Act to the 1968 Act, they replaced larceny in dwelling houses. Appropriation, they replaced taking and carrying away. So as you can see, appropriation, the word appropriation wasn't used here, but it is used in the new Act. And instead, taking and carrying away used to be considered, because now covering electricity. So that's interesting. Dishonesty replaced fraudulently, ultimately because it's easier for the jury to understand, but I really question that, to be honest. Okay, so that's the history, the Larceny Act of 1916. So now let's move on, or break down the categories of the Theft Act of 1968. So we have a number of different criteria. We have, let's start at the very top. We have appropriation. We're going to break down what that means. We're going to break down what is meant by property belonging to another. We're going to break down what is meant by intention of permanent deprivation. We're going to break down what is meant by dishonesty. So let's start from the very top. Okay, so appropriation. So the first is just a number of examples. We also have, well, what does this actually mean? So I think it's better to start with what does this actually mean before we jump into the examples. So Section 3 of the 1968 Act defines appropriation, and it means this: any assumption by a person of the rights of the owner. This is a wider scope than the old notion of taking and carrying away. Okay, so that does a bit better job of actually explaining what we mean by appropriation, the assumption of the rights of the owner. But this is obviously quite a complex area, and situationally this can cause quite a lot of problems, as we will see in the example section. So let's hop right into the examples. Okay, so we're going to give some actual cases that dealt with this. So there are a number of cases, as you can see. Let's start with the Lawrence case, because this was one of the main cases that you would learn if you studied law, or criminal law more particularly. So ultimately it was to do with, or following on from a taxi ride. It was a tourist that opened their wallet to take out the correct fare, and the driver took more than was required. And this was actually considered theft, even though the driver had the consent of the tourist, of the owner of the cash. And one of the big things that we should take away from this act is that they removed without the consent of the owner requirement in the 1916 Act. This was actually showing what effect the 1968 Act actually had on the real life cases and experiences of the people. Because now certain crimes of deception are now identical to theft. What does this actually do in actually merging the boundaries between theft and fraud? Problematic because it's separate moral foundation, that of theft and that of fraud. Take that as you will. But there's a trail of cases that followed from this, because we had, that is a very big one, isn't it? We had the R and Morris 1984 case. And ultimately the defendant, and when I say D and C, D is defendant, C is claimant. D switched the labels on an item in a shop to buy them at a cheaper price, claiming that they had the implied consent of the owner. Obviously this makes sense that they were charged with theft, because they assumed the right of the owner of the shop, obviously. Involved some adverse interference or usurpation of the owner's rights. Appropriation, okay, that's basically it. And this was affirmed in the R and Skip 1975, but it was overruled in Gomez. Gomez is a case that we will touch on just after I finish the bottom bit. And this case ultimately showed that we shouldn't consider appropriation in isolation. And the courts really preferred the use of the term dishonest appropriation. I don't know whether this is just a linguistic mark or whether this actually has some significant change in the law. That's for you to consider. But it's also very problematic because it's introducing the mental element to the AR, so the actus reus. So the Gomez case, so what was this? This actually followed on, and this is a huge one as well. So Gomez was actually a case in 1983. So the defendant was let's see if I can make this a bit, there we go, that does a better job at it. So the defendant was an assistant shop manager, and the defendant received 2 stolen checks as payment for goods and persuaded his manager to accept, lying, said that they were acceptable. Obviously this is theft, but it's really interesting on a theoretical level because it questioned appropriation and whether this is actually shifting to one of dishonesty, whether if we find appropriation through dishonesty, but they're completely different moral foundations and criterias. So you see what's happening here, introducing a subjective basis for appropriation. But this ultimately overruled the Morris case, which you just talked about, and you can read that there. Okay, so that's that section done. Now we're going to do the R and Pitton case. The victim was taken to prison. The friend took someone after the victims went to prison to the victim's house or flat and offered the victim goods for sale. And the friend was actually charged with theft because you interfered with assuming the owner's rights, even though they hadn't actually touched them. So this is with regards to assumption of the owner's rights. And this is quite interesting because the consequence of this decision, merely offering to sell something that isn't yours, constitutes theft. So that appropriation is actually expanded in this case. And then another example is the Hinks case, and this is a huge one within the theft law literature because it was to do with a defendant who worked at a care home. The victim was the resident, and the defendant persuaded the elderly victim to withdraw £300 each day with his consent to put into her account. And this person was rightly charged with theft. Appeal was dismissed. And what this ultimately did was actually adopt a narrower definition for appropriation. And we learn a lot of things. Well, Lord Harton was one of the dissenting judges on this case, and he said a valid gift cannot be dishonest. And we also show quite bigger issues at play, because we're seeing a conflict between civil and criminal law, because this would have been regarded as a valid gift, but it also may be invalid if we adopted the civil approach of ruling it out because of undue influence or unconscionability. And the problems really arise in the rule of law and the harm principle, because we really shouldn't be merging criminal and civil law together. And this also reduces the actus reus to vanishing point, because as the actus reus shrinks, the mens rea concept of dishonesty, as we're seeing with the cases that we touched on earlier, of dishonesty increase, because we remove not only significant limitation that survived from Gomez. And this really touches on serious international human rights principles here, and the erosion of manifest criminality. Look that up, it's quite interesting, and I'm not going to cover it here. So let's go back. So that is the appropriation section finished. Okay, so we've done appropriation. Let's move on to the next one, and that is property belonging to another. Okay, so there are a number of things we're going to talk about. We're talking about some of the cases, so some of the interesting real life scenarios here. We're going to look into, firstly, what is property as well. What do we mean by property? And what else are we going to talk about? We're going to talk about specific sections in the Act that are quite interesting, things that you should know. Okay, so let's start with the most obvious one. What do we mean by the word property? Because it's a lot more confusing than you might think. So property is real property, so land, but this also includes personal property. This could also be a thing in action, a chose of action. And this is also important because we're not necessarily including land, unless if it's something on the land. For example, if you have a wheelbarrow that's on the land, that would obviously be property. Okay, and then wild creatures are legally considered as property. That's quite interesting. I'd love to hear what you think about that. Electricity. So this is quite interesting because dishonestly wasting electricity is considered not necessarily theft, but it is liable for imprisonment. So water and gas can be stolen in this scenario, but not necessarily electricity as such. I think we need a bit more clarity on this point because the law is relatively unclear in this section. And then parts of bodies, bodily products and corpses are not property unless taken into possession of a hospital or someone's control. So obviously there's a lot of loopholes here as well. Now let's go on to some of the big cases. So let's start from the top. So the Oxford and Moss case, this is quite an interesting case. I would read up on it. It's interesting because it actually looks into whether information is considered property or not. Okay, next case. So we have the Meredith of 1973 case. And this one's also really interesting because the defendant's car was taken by the police and taken to the police station. And the defendant drove off with his car without the permission of the police. The defendant was acquitted of theft, but they may have to pay a fine though. So that's quite interesting with regards to property belonging to the other, because it technically is his property, but it was under the custody of the police at the time. So we have the Rose and Matt case, which you can have a read through that. Defendant owned a clock, left it as deposit for goods, and this is theft, or this is considered theft because the defendant later took the clock when no one was looking, which makes sense, I would say. And then the Turner case, this one's one of my favourites because the defendant took the car to the garage for repair. He later retook the car without paying for the repairs. The defendant was convicted because the garage had lawful control of his property, so it was not necessarily under his control in this circumstance. Do a bit more research about this one. I think there's a lot more interesting information you can extract from it. Yeah. Okay, so that's some of the cases covered. Yet again, I would also say that please look into these cases in more detail. This is my interpretation or my values that I've extracted from it. Please extract your own depending on what cause or what you're interested in generally. Right, so section 5.3. This one's quite interesting because the property in question given to a person must be used in a specific way. Because the property in question given to a person to use in a specific way, for example, ownership of it remains with the giver. If they don't deal with it in this particular way that the owner said, it may amount to theft. Now, this is always going to be quite a tricky one, and thinking of examples for this, there's probably quite a few, but it's a bit of a sticky one. So that's quite interesting. And then we have section 5.4. So that says this: person receives property by mistake, they are under an obligation to return it. A failure to return it will amount in theft. So this is a really important section that I would advise you to have a look at yourself. Type in Theft Act 1968, section 5.4, read it yourself. There's a bit more detail, but that's ultimately what it says. Okay, and that is property belonging to another. Right, another third is this one. Intention of permanent deprivation. This one's quite interesting. So, firstly, what does this mean? Secondly, cases. Third, significant practical detriment. I'll explain that in a bit more detail in a second, but let's start at the top. So what does this actually mean? So there's not necessarily an actual definition for any of these words used here, but for example, deprivation is generally considered what we reasonably consider the word deprivation to mean. So depriving a particular owner of an item. Even when there is no intention to gain, this can still amount to theft. And this is a key point here. And even under section 6, we can look at temporary deprivation, such as recklessly damaging a car, because this is quite interesting. If you treat someone else's property as your own right to dispose of, or equivalent to an outright taking, this comes under permanent deprivation, even though the deprivation might only be temporary. Have a look at section 6 for more detail. So let's give some cases. So we have Mitchell, 2008, and Marshall. So in the Mitchell case, 2008, the defendant violently hijacked the victim's car, abandoning it a few miles away. Originally convicted of robbery because there was some sort of force involved, but ultimately robbery couldn't be charged because the theft requirement wasn't filled. That was the intention to permanently deprive the victim of the car because, well, they didn't permanently deprive the victim because they abandoned it a few miles away. But when we considered what I said earlier about this temporary deprivation, feel free to disagree with this case, because I personally do, because the defendant definitely did treat it as his own right to dispose of, and it did amount to an outright taking. So bear that in mind. The other case, R and Marshall. So this one's quite interesting because the defendant asked victims at train stations for their travel cards and then resold them, convicted of theft. Although there was no intention to permanently keep the travel cards, the act of reselling amounted to an act of an outright taking, and therefore that was considered theft. And now the next one, significant practical detriment. So what do I actually mean by that? So this was actually a proposal by an Australian court case where they said, okay, I don't like this idea of intention to permanently deprive, let's replace it with this. And this is what it ultimately means. So suggested by Justice McGarvey, and it's the idea that if you obtain property dishonestly from a person who is deprived of it, it affects their interest in a significantly practical way. And this is actually the law used in the Australian Capital Territory. So yeah, you can think about that, whether this is actually better than the intention of permanent deprivation. Look at it in more detail, see if it's something of consideration here. Okay, so that's intention of permanent deprivation, and the last one is dishonesty. So let's explore that in a bit more detail. So let's start with what does it mean and the cases. So what does it mean? So there's actually no definition of dishonesty in the 1968 Act, but there's partial definitions in section 2 of the Act. And this is what it says. It's not necessarily seen as dishonest when the defendant believes they have a right to deprive another of appropriation. For example, accidentally taking someone else's umbrella, thinking that it was yours. Or ultimately, if you believe that they would have the other's consent, or if you appropriated property in the belief that the owner cannot be reasonably discovered. This is an objective test, so take that in mind. Objective meaning judged by the standards of a reasonable person, not subjective, what you were thinking at the time. And section 2.2 says the willingness to pay will not necessarily prevent the defendant being found dishonest. So you can probably think of a couple scenarios where this would apply. Okay, so we've done what does it mean. Now let's go on to the last bit, cases. So this is quite interesting because there's a string of cases that apply here. So the first is the Ghosh 1982 case, and this is ultimately about a surgeon who claimed fees for work that others had carried out and was rightly convicted of theft because the surgeon was acting dishonestly. And it established a two-part test to identify dishonesty. The first is that, was it objectively dishonest? And if it was, you ask then, is it subjectively dishonest? But this test was actually changed in a later case, in the Ivy and Genting case in 2017. And this case was to do with a defendant who was a gambler that used a system called edge sorting to win millions of pounds. And the casino refused to pay. The defendant was charged with dishonesty, and they changed the ghost chest, which has actually been around for 30 plus years until it was recently changed in 2017. And it ultimately removed the subjective limb of the ghost test. So the ghost test applies, but we're just removing the subjective limb. You just have to ask whether it was objectively dishonest now. And that's the test done. And that is it, guys. A complete guide of theft under the law of England and Wales. Thank you for listening. Please say in the comments which section you found the most interesting and if you learned anything new. Once again, I may have missed certain bits or certain key cases that you think might be useful to highlight here, or any key sections. Please say so in the comments. That would be much appreciated. If you like this style, if you want me to keep on doing things like this, please say so, because I'll be more than happy to. And I am a small channel, so please do, if you've got any requests in the comments, please say so, and I can definitely do this probably within a week. So yes, comment.